Hello and welcome to Legally Speaking with me, Tarun Nangia. This is our part two on the law of bail. Especially, we may be seeing in the recent past there have been a spate of arrests. Sometimes bail takes too long. Many times, businessmen are inside there, unable to run businesses because in India, businesses are promoter driven. And that is why a discussion of the law of bail is important given the kind of crimes and also the kind of arrests that have happened in the past few months. I have with me Advocate Malak Bhatt. He's represented some of the big businessmen recently. Case in point being the promoters of M3M recently you got bail from none other than the Supreme Court of India. All the way they had to go to the Supreme Court to get bail. And so, in his experience, why he finds sometimes that businessmen take a lot of time to get bail, but people who've done other crimes may get off bail more earlier. We will get to know all of this and more from him. Good to see you, Mr. Bhatt, and looking forward to some interesting discussion today.
Thanks, Tarun. It's always pleasure to be here.
Now, I want to know from you if you look at the businessmen community, a lot of them have seen jail time. Uh, could you tell us people accused of other heinous crimes who end up getting bail and businessmen are thrown in jail without bail? Uh, what is happening here and why some people get bail? Why for the similar offense somebody are denied bail? Could you give me a longest 3.5 minute answer and explain this?
Sure. So let me just step back a bit first and let's go back to the general principles of bail. So if you see the general law under the CRPC, when you talk about the powers of arrest under 41 of the CRPC, you are looking at a provision where the police could have the power to arrest if they have a suspicion that that person has committed a particular offense or not. The idea behind securing that person's apprehension is to ensure that the investigation that the police is going to conduct is not impeded in any manner. The person does not flee from justice, and he's made available at the time, if at all, a charge sheet is to be filed against him. So largely what used to happen in general offenses, either under IPC or other cases, is that once a charge sheet is filed, investigation is complete, the police has completed its role with respect to that person. He's in judicial custody, which means he's today under the custody of the court. The court enlarges that person on bail, knowing fully well that he will remain available for the trial by placing normal conditions like not leaving the country, not leaving the city in some matters, reporting to the investigating agency on a regular basis. Now, over the past 5 or 6 years, the economic scenario in the country has changed a lot because we saw a lot of bank defaults. So if you see the trajectory from 2016 onwards, a lot of companies turned NPA. With the RBI coming down very heavily on banks, the banks were mandated to conduct a lot of forensic exercises. And during these conducts, they found that there were many economic frauds which were taking place in companies by way of diversions, by way of siphoning funds. There were large scale provisionings being made. Either the books of accounts were fudged or there were overstatements in the sales or purchases, etc. And over a period of time, the courts have started giving economic offenses a higher magnitude of being an offense as compared to other, I would say, blue collar crime offenses. So today, you have the Supreme Court echoing this over a period of at least 4 or 5 judgments now, saying that money laundering or white collar crimes are at par as modern terrorism. And that's where you see a shift where courts are very stringent when it comes to bail. For 2 reasons. One, the apprehension that people who generally are influential have been running these businesses, have been able to broker or allegedly broker some benefits for them, may flee from justice and ultimately not face trial. The second is also because in large scale matters, sometimes when the public gets defrauded, for example, let's take the example of a real estate company where the home buyers' interests are at stake, or public depositors where the monies of public who are deposited with the public depositing company are not being repaid. So when the economic interest of the country is at large, suddenly from an optical standpoint also, it kind of affects the economic interest of the country, which hampers the grant of bail. Now, coupled with that is the other part where in most of these cases which we are seeing where investigations are being conducted are under special statutes. So you are looking at the PMLA, you are looking at the Companies Act where the SFI was conducting investigation. In both these circumstances, there are, apart from the regular law of bail under 413 of the CRPC, more stringent conditions for even the grant of bail. So you have section 45 today standing on the books of the PMLA. You have section 202 subsection 6 standing on the books of Companies Act, which say that apart from the conditions of bill under 439, the additional twin condition will also have to be met by the accused. One of them being that you will have to prima facie show that you have not committed the offense. So the burden of getting bail in these matters are much higher as compared to a normal case where someone could just argue that, look, today investigation against me is complete, charge sheet stands filed, I am no longer required by the investigating agency to be in custody, release me on bail. That may not suffice, and that's the reason why today we are seeing the trend of bails becoming more and more difficult, where the accused today has to stand that test of the twin condition and prove that he has actually not committed the crime, or there are various other factors in his favor which actually lead to a situation where he can be able to get bail.
Okay. Point well taken. See, in the business community today, for example, say a class of businessmen, say builders, many times they are in jail and they are unable to run their businesses from inside jail. And in India, business tend to be driven by the promoters. So, what the court has to be convinced of for these kind of people to be out so that they can deliver on their commitments, in one example like delivery of apartments or commercial plots or commercial assets, servicing loan to banks, paying salaries, etc., etc. Because just by putting the businessman in jail, even the banks go at risk, and we see many times loans turn NPA because of that. You understand this better, so could you share this with us?
No, absolutely, and this is a very pertinent point that you highlighted. So let's take you from where a lot of this started actually. So Justice Chandrachud, while making this a condition for bail in Sanjay Chandra's matter, had put in a condition that you will be able to secure interim bail only if you put in 750 crores in deposit of the money which has been allegedly siphoned out, so that that money could then ultimately be paid to the home buyers. Now, see, one thing is that a lot of these business interests which hold stake when a promoter goes into jail is actually also a sentimental value which when there is a hit on the company. So a lot of times the court also needs to take a balancing approach on these things, and which is why a lot of times when we move applications for interim bails or bails, we make this an approach to highlight to the court that, look, today if I go into custody, if I stay in custody, the company which today is otherwise surviving well is delivering its commitments to the banks, to the stakeholders, be it so for a real estate company, be it home buyers, or for a investment company, be it customers. If the person who's running the show today is not available at the helm of the affairs for a long time, you are ultimately going to impact them as well. And these were one of the 2 or 3 main grounds we've taken recently in the high courts also. And the high courts also found favor that, look, I can secure the person's presence by today releasing him for a period of 4 or 5 weeks, let him manage the affairs and then probably go back. Or to ensure that the person is available to the investigating agency throughout the period of his bail. But these are economic outlooks which the court ought to have considered in most of the cases, but unfortunately they are not. In fact, I'll interestingly also point out one more thing here. So in the USA, for example, while it may be at the stage after the inquiry is over and it's at the stage of conviction, there is also a system called a deferred prosecution agreement or a non-prosecution agreement, where the party voluntarily comes forward and says that, look, I don't want to stop my business. I am facing an inquiry. I understand that there may be some discrepancies in the way in which my functioning has taken place. So what I'll do is I'll pay a fine to you, but I'll also put in checks and balances in my system, which you can monitor as say the Department of Justice, and I will compensate the people who have allegedly lost money because of the fault that you have found. So see, these are kind of nuances which today the courts will also have to start being abreast about, because simply by keeping the person in custody, especially in cases where the trials are not proceeding, where the investigations are not completed in a time-bound manner, it's impacting a lot of other third-party victims today who otherwise would stand to get their commitments delivered or at least honored if that person was made to say granted bail on a condition that if you don't make the payment within X amount of time, you will send back to custody. So a lot of times, for example, someone can also, and this in fact recently happened in UK also, bail was granted on the condition that the amount which was allegedly siphoned out will be repaid by the person employing himself as a consultant in the company from where he was ousted, and through the salary that he's being paid, he'll pay back the money. So these are interests which one has to balance, because ultimately, apart from interests of the home buyers, you're also look or the stakeholders, you're also looking at interests of liberty, and the question of liberty will have to then be addressed by the courts within the four corners of these stringent provisions.
If you could simply tell me, when businessmen don't get bail, and I'm talking of businessmen who run complex companies. See, when you have 5-6,000 employees, it's a complex structure. There are multiple payments, multiple cycles where money comes from and goes into. Not a simple mom and shop operation. I'm talking of big operation. Do you think generally it is counterproductive to keep the businessman in jail in such cases?
See, it is counterproductive for the purpose of the company, yes, but one also cannot lose sight of the fact that today investigating agencies are doing their role of investigating a criminal offense. So merely because you are a big businessman or the company is too big to fail cannot become a reason for you not to be arrested if you have actually committed the crime. Because one also has to realize that these agencies, when they arrest, they are meeting a threshold, as I told you, unlike a normal police under 439, which can arrest at suspicion, are actually dealing with.
I want to hold you here and I want to know for you, sorry for interrupting. If a businessman, a big businessman, be it a builder or a manufacturer or a trader, if he is found guilty, he can serve a jail term. But to your reason mind, does it appear okay that without being convicted, he spends years inside jail?
Right. So that's what I was coming to, that at a stage where the agency is arresting that person, they're arresting after, in terms of the provision of law, they have enough material to suggest that he's guilty of the offense. See, there's a difference. The provision is at a very harsh level. So if you come back to the judgment in Pankaj Bansal, court said you have to meet that threshold to actually arrest that person. If you've arrested that person, the purpose of the arrest is to show that that person has committed the offense. However, the reason behind someone's arrest is that he can be put to trial early. One's custody also has to go in line with the fact that he cannot be incarcerated for an indefinite period of time. So if you see, very pertinent point raised in Manish Sisodia's judgment, that a trial cannot continue indefinitely, and in fact, Justice Khanna has used the language very beautifully. He says that if there is continuous incarceration without the trial being, even commenced, the person ought to be released on bail as a matter of right. So continuous incarceration in matters like this is detrimental to that particular person's liberty, but also detrimental to the economic interest of the company and of the country, in fact, I would say. Because a lot of times when these companies are working pan India across various states, let's take an example of a public listed company. We've seen that, because a lot of these information obviously has to also be shared on the stock exchanges. The moment a promoter of a big company is arrested, the stock prices of that company fall by a huge margin. And that's today impacting not just him, but also the person today who's holding a share in his company. Because what matters to him is that, yes, there may be no diversion, but at the same time, till the time the trial is going on, that person today holds the position which he has to ensure that the company does not go bust. And that's one thing which has to definitely be considered very importantly in the mind of the court. In fact, I'll just, before you go on to the next question, let me highlight, yesterday there was a judgment passed in one of our matters by the Supreme Court, where they've said that yes, trials have to be completed in a reasonable time, but at the same time they've placed a very high burden on the accused to show a lot of things to be able to secure bail. Now, in a situation like this, where for 18, the maximum punishment under the special statute, say 7 years or 10 years, you've already spent about 2.5 years in custody with the trial not even seeing the light of day. You're still at the stage which is much prior to the trial, forget inquiry. The person's incarceration is ruining not just the functioning of the company, but also everyone that the company has to today deliver to.
So you strongly feel about this denial of bail in that sense.
Absolutely.
Uh, if you could tell me one thing, is there any predictability in the Indian legal system vis-a-vis bail, or it is highly discretion dependent?
See, it's bail as a law itself is discretionary. There is no straitjacket formula, and every court, when it starts a judgment or an order, always says that be it bail or anticipatory bail, there is no there's no 1 2 plus 2 equals 4 in this. It all depends on the facts and circumstances of the case. However, I feel over a period of time, the Supreme Court and various high courts have at least devised 2 or 3 factors which I feel now is there's high time court should start considering as a standard formula to apply at least to cross the basic threshold of grant of bail. And those 4 or 5 factors today should be at least the 4 factors that come to mind immediately are: number one, is the investigation against that person complete or not? If is he really required to be in custody for a period when the investigation against other accused are ongoing, where the trial is not starting, where the documents are so voluminous that the scrutiny of documents is going to take time? Number two, is there a possibility that the person is likely to free from justice completely, or are there ways of securing his presence at the trial by imposing conditions like opening a lookout circular, or by ensuring that he attends to the agency or the trial court's presence every 1 week or fortnightly, etc. Number three, and most importantly, is the trial likely to be completed anytime in the near future? And this is a very, very big factor when it comes to investigations, specialized investigations by, say, the ED or the SFIO, where we have seen that there are more than 100 accused, about 1 lakh documents being filed, supplementary complaints being filed every 4 months, a new accused being added. So it's not a situation where you are going to look at even the charge being framed in the first 1.5 2 years of the person being arrested. In such a situation, is that 2 year period really required for the person to be in judicial custody, or can you counterbalance his personal liberty with the balance of interest of the investigating agency and a very important balancing interest of the people at large? If you can, then he has to be released on bail. And the fourth factor, obviously, is, as most importantly, is liberty. Because today, pre-trial detention at a stage where tomorrow, if I am to be acquitted and I have spent 2 years or 1 year in custody for a case where I ultimately am going to be exonerated, or I have probably to show I'm going to be exonerated, but I have lost my entire value of the work that I've done only because of that 1 year of being in custody. Because see, ultimately, it's also detrimental for institutions like this optically to see that the main person's in custody, because the talk that goes around, or the media that covers these issues will always term that company to be under ages of someone who is today facing a criminal trial or being in judicial custody. So that one thing, I think, is it's high time that the courts start looking at these 4 or 5 factors which are well entrenched in judgments but have to be taken on board and highlighted in every judgment that comes in.
That's all. So you mean courts have to reiterate what they have earlier said?
And
Because
be conscious of that. See, one part is reiterating what is already said, but I feel commercial realities and these factors have to be actively brought out by the courts in actually implementing them and granting people bail. Because today you're flooding courts with business people where the trials are not seeing the light of day, things are not moving as far as courts are concerned. You are only having you have them behind bars only because there's a stringent condition of bail, and you feel that the economic interest of the country will be better served if they remain in custody, which, in my respectful submission, may not be so.
you mean it could have a reverse impact in the sense scaring off other businessmen?
I would say one part of this is scaring off. The other part is overcautiousness. I mean, I'm
You
not
mean you may not want to do so much business because you'll always feel I may fall foul of the law.
absolutely, because today it's easier for a bank to conduct a one-sided forensic audit and to have a CBI complaint against you so that they are clear of their work, saying that, look, we've done our work. But a lot of times these are not diversions. A lot of times these are active business calls that the business people would have taken to ensure that the actual stakeholders in these companies get benefited. These may be conscious commercial decisions which may sound foolish but not criminal, and that's one thing which I think the courts need to really keep in their mind. Because what happens, and since you raised the issue of cautiousness, let me also just bring this out over here. We've actually seen people tell us that we don't want to diversify, or we don't want to raise further capital because we are scared that if if further due diligence is going to be conducted later on, if things go bad, we'll ultimately face an investigation by a specialized agency.
So you mean that there is already a certain fear that you may be investigated? Uh, do you feel that this is more on the lines of not purely law but practical business? Do you think too much of an investigation into any company is generally a problem?
Uh, I'll answer this in two ways. You cannot stop an investigation only because the company is doing business. That is not what the law says. Because if there is any element of criminality found, the investigating agency should and ought to investigate. You cannot, just because you're a businessman, you cannot steer clear of the law. If there is something which is found to be wrong, or there's a wrongdoing which is alleged, because see today, the agencies and the people sitting on top of the agencies are also specialized people. They know what exactly they're looking at. So not every complaint is entertained, not every allegation is really investigated into. But yes, the contours of the investigation, on the other hand, should be such that they preserve the integrity of the business of the company, which otherwise is not tarnished. Yet the investigation should not be so blown out that anything and everything that may not look ideal or good in terms of what the agency feels becomes an offense. So let's answer this question simply. A decision today in the mind of the board which may ultimately benefit the company may be a negligent act, maybe a brash act, maybe an act which ought not to have been taken in hindsight. But that does not give it a criminal angle. If there was no intent at that particular time to actually divert the funds or to launder or to actually commit a crime. So today, after say 5 years of the act being committed, an agency sitting on top and saying, look, you did this and this led to this, and therefore there was a criminal act, is something that should definitely be avoided.
That's a very, you put it very succinctly and in brief, but it conveyed the message. One final comment from you. In every country, the law grows and progresses from the learnings of earlier judgments of the court. And we see many times court revise their judgments in similar cases at different times. Do you think, as you earlier said, that in India, liberty needs to be reiterated again and again and again by the courts because this message should go down to the lowest court, or as we call the district judiciary?
Absolutely. It definitely should. In fact, Abraham Lincoln once very nicely said that the philosophy of the classroom today is going to be the philosophy of the government tomorrow. And that today translates, as far as the judicial system is concerned, from uh, the first principles being reiterated and entrenched by the Supreme Court for all courts to follow. So I think the best example today which comes to mind is the judgment in Satyendra Kumar Until by Justice Kaul, which laid down a very, very beautifully counterbalanced approach between liberty and grant of bail. When the courts there reiterated that, look, if someone's not arrested by the agency, there is no need for the courts to put them in custody and let them be made available for trial without really bothering them with judicial incarceration. Active directions were passed to ensure that the judgment is taught at the judicial academies, is then proliferated by the high courts to the district courts. Judges are trained on these issues. They are made abreast of the actual findings of the court. And I think that's today what is the most important thing, that whatever liberty oriented ideas or judgments are being passed with the Supreme Court, they should definitely be passed on, and they should definitely be taught in law schools, and at the same time be brought to the notice of all trial courts and high courts.
Thank you. This has been an entertaining, informing, and a very serious conversation, but it also gave us various shades of what businessmen go through, gave us an insight into what the courts have done, what the courts also ought to do, what investigations, in a sense, should be all about. A pleasure to talk to you on all of this on the law of bail. Thank you so much for coming and participating on the show. Thank you so much.
Thanks, Tarun.